So I want to address this issue of public charge. And this is the prior administration implemented a change to this longstanding immigration rule called public charge in 2019. And the rule took effect February 24th, 2020, just days before the pandemic that we're still experiencing. A lot of public health experts warned when the rule was proposed that this was such a bad idea because it would have an impact on immigrant communities if, God forbid, we were to find ourselves in a public health crisis like the one we're now in. But in reality, the rule began having impact on immigrant communities' willingness to access certain public benefits, even at the beginning of the prior administration in 2017. So I want to point out a few things that I think are really important for folks to have in mind right now as we're in this moment of significant transition at the federal level. First of all, during the campaign, Joe Biden committed to reversing the public charge rule that was implemented. And last week, President Biden issued an executive order that essentially marks the first step in that process, ordering several government agencies to assess the public charge rule. So we know that the Biden administration is beginning those formal steps to reverse the rule, but it's going to take some time. And the exact amount of time and exactly how that will proceed, we can't say with certainty right now. We can say that this rule that the prior administration implemented is a rule that the Biden administration has full legal authority to undo. Because of the way the prior administration did this, it cannot be eliminated on day one by executive order. This administration has to go through a process to undo it. But with that in mind, I want to point out a few things. First of all, the public charge rule only applies to certain immigrants at certain points in an application process, when they're trying to come into the country on certain visas, or when they're applying to adjust their status, generally to legal permanent residence through the family-based immigration process, or to extend a visa if they're already here. And then many immigrants are simply not subject to the public charge rule at all. And this includes immigrants in many humanitarian-based immigration categories, like the U visa for victims of violent crime, including domestic violence, the T visa for trafficking survivors, Violence Against Women Act for people who have suffered domestic abuse by a US citizen or permanent resident, spouse or parent, and then asylees and refugees and children who may receive a status called special immigrant juvenile status. The public charge rule doesn't apply to them at all. Another huge category where the public charge rule doesn't apply is that of legal permanent residents, going about their lives here, going through a naturalization process. Legal permanent residents are not subject to this public charge test unless they leave the United States for 6 months or more and then seek to return, or if they seek to re-enter the US with certain criminal history. But otherwise, if they're going about their life here, they're going through a citizenship application process, they're not subject to this public charge rule that has caused so much concern in the community. And then, really important point I want to make, because we've seen some questions in this already in the chat, benefits received by household members are not considered in the public charge test. And I'm talking about this current public charge rule that the Biden administration has taken the first step to undo. Benefits received by US citizen children do not count against a parent in their future application process if they're subject to the public charge test. So if you have a child who's receiving CalFresh or CalWorks, and they qualify because they're a US citizen, and you hope to get status through a petition by a relative, maybe your spouse, maybe a sibling, those benefits that your child receives will not count against you in your application process. And then I want to move on to another slide that emphasizes this last point, that many benefits are not considered at all. And so we're going to take a look at that a little bit here. So Right now, we're still in the midst of this COVID pandemic. Really important to clarify that any COVID-19 related testing, medical treatment, or vaccination is not factored into any future public charge test. US Citizenship and Immigration Services clarified this in writing on its website at the outset of the pandemic. And then there are many state and locally funded health programs that have no public charge consequence for an immigrant. So the state of California has made Medi-Cal available to all Californians, regardless of immigration status, who are low income, up to age 26. And so the state is paying for that program, not the federal government. And there is no public charge consequence to a Californian who receives that benefit. Here in Los Angeles County, we have the My Health LA program to provide important health services to uninsured persons in our county, regardless of immigration status. The county pays for that. That program is not considered in any future immigration application where an immigrant may be subject to a public charge test. Okay, and then also very important that many immigrants qualify for earned employment benefits, like unemployment insurance. Now, to qualify for unemployment, an immigrant does have to have employment authorization. DACA beneficiaries, TPS beneficiaries they're not permanent residents yet, but they're employment authorized. Well, they've paid into this system, and this is considered an earned benefit that is not subject to consideration in a future public charge test. Same with disability, paid family leave, and workers' compensation. And those benefits, California has made available to all workers, regardless of immigration status, if they meet the rest of the eligibility criteria. And then there are important tax credits, such as the California Earned Income Tax Credit, which this year for the first time, and the Young Child Tax Credit that California has expanded to ITIN filers, people with the taxpayer identification number that they may use because they may lack a social security number. So people filing for that tax credit, they're getting money back that they've paid into the system. There is no public charge consequence if they receive that benefit. And then beyond that, there are a number of important emergency benefits that folks need and may continue to need during the pandemic and during the recovery period. So medical sheltering for folks that can't safely isolate or quarantine in their home. The county has medical sheltering facilities available, emergency food resources from pantries and other locations. And then fixed term, short term emergency aid, even one-time cash assistance or assistance through the city and the county's programs to help keep people in their homes, such as the Stay Housed LA program. The benefits provided in those programs, those are emergency benefits that are not factored into a public charge test. And then finally, if it wasn't clear in the last slide, benefits received by household members. This is among the most common questions that our counselors at the Office of Immigrant Affairs receive, whether there's going to be an impact on my future immigration process because my US citizen child is receiving or needs to receive some kind of public assistance. And the answer is very clearly, even under this problematic rule that we're still living with, the answer is very clearly no. If you have other questions, please call our office. This has been our most common inquiry during the pandemic. We have counselors standing by ready to answer those questions. And with that, I just want to note folks are posting some questions in the chat related to some basics on DACA eligibility, individuals with disabilities and whether they may be eligible for immigration status.